What is the difference between a living trust and a will? Both tools distribute your property, but they differ in when they take effect and whether probate is required. A living trust operates during your lifetime and lets you manage assets as trustee while avoiding probate court. In New York, the creator of the trust is the truster and typically serves as the initial trustee, naming a successor to step in if needed. A trust can be revocable, allowing you to change terms or dissolve it at any time, or irrevocable, which offers asset protection but less control. A will is a written document that directs the distribution of your assets only after your death. To be valid under EPTL Section 3-2.1, it must be signed by the testator and witnessed by two people. A will has no legal effect until you pass away, so it does not help with incapacity planning. After death, the will goes through the surrogate's court probate process, which involves validation, notification of beneficiaries, payment of debts, and distribution. Probate often lasts at least 7 months and can be much longer if the estate is complex or contested. A living trust avoids probate for properly funded assets, enabling your successor trustee to distribute property without court supervision. This often means faster settlement and more privacy, because the trust document remains private while a probated will becomes public record. If privacy is important or family dynamics are sensitive, the confidentiality of a living trust may be a significant advantage. To make a trust work, you must retitle your assets into the trust's name, such as real estate, bank accounts, and investments. This funding process requires ongoing attention because new assets acquired after the trust is created must also be transferred. In contrast, property addressed in a will stays in your personal name, so you do not need to retitle assets during your lifetime. Wills are generally less expensive to create, but probate costs, court fees, and executor commissions may be incurred after death. A living trust may cost more upfront, yet it can reduce or avoid probate expenses and delays for assets that are properly funded. Most comprehensive estate plans include both a living trust and a pour-over will that directs overlooked assets into the trust. A pour-over will ensures that property not previously transferred still ends up governed by the trust terms, though it must still go through probate. For estates under $50,000, a simple will may suffice and may qualify for streamlined probate. A living trust is often advantageous if you own real estate, have beneficiaries in multiple states, value privacy, or wish to plan for incapacity. Families with businesses or property across different jurisdictions may avoid multiple probate proceedings because a successor trustee can administer trust assets in all states. Frederick P. Davies founded Davies Law Firm in 1993 after a distinguished legal career that included military service as a judge advocate general. He has delivered numerous seminars on estate and elder law topics and draws on nearly 40 years of experience to advise clients. William P. Davies, a partner at the firm, holds advanced degrees in estate planning and focuses on wills, trusts, tax strategies, and estate administration. Each attorney at the firm combines academic rigor with practical experience to provide clear guidance to Central New York families. Working with a knowledgeable estate planning lawyer can help you weigh the pros and cons of each tool and tailor a plan to your needs. Contact Davies Law Firm to schedule a telephone conference and learn which estate planning tools are appropriate for your situation. Our office at 210 East Fayette Street, Syracuse, New York, 13202, welcomes clients from Onondaga, Madison, Oneida, Cortland, Oswego, and Cayuga counties. You can reach us at 315-472-6511 to speak with an attorney and begin creating a plan that protects your family and your legacy. Choosing the right lawyer can make the difference between a smooth estate plan and unnecessary court involvement.